Good evening, and welcome to this online conference on occupation crimes against prisoners before international courts. This conference is organized by Asra, the European Alliance in Defense of Palestinian Detainees. My name is Peter Eisenstein. I am the honorary president of Asra, as well as the deputy chair of the Norwegian Peace and Justice Party. Asra, the European Alliance in Defense of Palestinian Detainees, was founded in 2014 when more than 50 Palestinian trade union and political figures from over 15 European countries joined forces to intensify and expand solidarity campaigns for the freedom fighters imprisoned by the occupation. And we have the privilege of having with us tonight experts and activists who will bring us up to date with the situation of detainees in Israeli occupation prisons, as well as the ongoing legal efforts here in Europe to both put an end to these crimes and hold those in power accountable. With us this evening are Jan Furman, a Belgian lawyer specializing in human rights and the former Secretary General of the International Association of Democratic Lawyers, Abdelhamid Siam, who is a United Nations independent expert coming to us from New York, Khalid Al-Shuali, founding member of the legal team, which has brought a case against Israeli officials at the International Criminal Court, Hassan Abadi, who is a Palestinian lawyer based in Haifa and who represents a number of detainees in Israeli occupation prisons, Kamil Abu Anish, who is a former detainee in an Israeli occupation prison, Geir-Kjell Andersland, who is a lawyer, activist, and member of Palestinian children in Israeli military prisons, and Alejandro Amaro, who is a Spanish human rights activist. The format for this evening are 3 sections with 2 or 3 speakers each. They will each talk for 10 to 15 minutes, and then at the end of each section, we'll have time for questions and answers. The first section will focus on the experiences of detainees and the lawyers who defend them. The second concerns international law, offensive and defensive actions. And lastly, state action versus individual action. With that, I would like to welcome our first speaker, Hassan Abadi. As mentioned, he is a Palestinian lawyer based in Haifa and who represents a number of detainees in Israeli occupation prisons. With that, if you can take it, Hassan, if you have the word. Yes, Hassan?
Good evening, ladies and gentlemen. Following the events of October 7th, their suffering has dramatically stripped even their most basic rights. There's no unable to be in touch the prisoners with any any person outside of the prison. The campaign of Abbas began even before the October 7th, with Itamar Ben-Gvir representative, the major setting the stage of escalating brutality, including provocative visits to prisoners. Because after that, there's no visits from the people, from the families, also from the most lawyers. And after that, after the 7th of October, prisoners were plunged into total isolation. They were denied any time outside their cells, cut of the interior from the outside world, no newspaper, no television, no radio, also the Hebrew newspaper, no more, like Ma'arif or Idiot Ahronot. As for the female prisoners, the torment begins upon arrest, continually from their homes, houses, and till they arrive Damoun prison. Their forced ride often take place in midnight, carried out by dozens of soldiers. Only 2 women and the other about 50 soldiers coming at home midnight, carried by dozens of soldiers. The inmates immediately turn from their families, subjected to strip searches, no clothes, not at all at home. And after that, they are often not followed to change out of their night clothes. Upon arrival at Sharon prison, the ordinary Debins women are subjected once again to strip searches. For most of them to have the strip searches, about Farah told me 12 times in the 10 days. Both individually and groups. Some of them to groups to make this search one with another, and also they have photos to them and by cameras. Some of them they face the threats or rape and horrifying warning to them to with the children to Gaza. The abuse, the verbal assaults, professionals under brutal and dragging conditions. Several female prisoners have also at the Sharon prison the black scorpion, a term with the woman or the soldier, which make damage for of them. For example, Fatma Sakir told me, I will never forget the face, even among a million others. Referring to one of her terminates, she also spoke of the intensive directed to her married brother Saleh. For 2 minutes come until Saleh died. Saleh no more. The isolation inside the prison sharply with the post-October 7 arrested. The number of the family detained jumped from 27 to around 120, and this week also 52 prisoners in Damoon. But because of that, 27, now we have 52. Many of the women are forced to sleep on the floor due to the lack of beds, no beds. Because today I visit the moon, and one of the rooms are 11 prisoners there, but they have only 6 beds. So 5 of them on the ground. Prisoners face harsh isolation with the animal time outside their cells, as well hunger and food deprivation. So most of them to be at the room 23 and a half hours each day, just for half an hour go out and to have wash or to see each other. And also there are no television, no phone. They can't, from the 7th of October till today, they can't see their families, be alone. And the lawyers just little bit. One prisoner described this collusion strictly. We undress. She told me, we are undress, wash, and wear the same clothes again. Some of them for 6 months don't change, don't have only one set for clothes. So the same clothes, just undress, wash, and wear it. Because of that, we heard about the scabies. Many of them are sick from that. Because they also, at the winter now, they have no clothes because they have only one set of clothes. So it's very cold for them, for the women and for the people, also for men. Male prisoners also mentioned about with additional campaign against them, because all the time they have, for example, 150 prisoners in one section instead of 50. Some rooms, and I have been in Galboa. Galboa, it's in the north of Palestine. There are at the same room 15 prisoners and have only 6 bed there. And also forcing them to undress and no, can't wash themselves, only once a week can wash. And many prisoners remain unshaving for months, no shaving for months because they don't have the opportunities to shave. And also about they have dogs come inside the rooms and to make trouble for the people to be make him afraid. And the question is, where is the Red Cross? Because the Red Cross, for example, are not have any humanitarian community to face what's going on. And also after the Tufan, everything became very, very bad. I meet this week Farah Abu Ayyash. Farah Abu Ayyash, I visited her. It's about 24 journalist, 24 years old, and she told me that she is now in El Damoon. In Damoon, it's beside Haifa. Farah recounts, I experienced so much horrific things. They arrested me at the middle of the night with dozens of soldiers, two female, and after that, number of jeeps and police vigils. I never imagined what happened for me. They take me to Kermet Sur and tied me to chair outside. And with this, tied me to chair next of pipe, driving filtry water into me all the time, all the night, outside. She also told me the female soldiers all the time shouting, and bring the dogs tour against me outside, and also they give me all the time. They push me all the time and boxing me. And when I complain for them, they take me to Ramla because the investigation are there, and they take my telephone and want to enter the code and everything. And all, she is a journalist. Farah also transfer her to Russian compound Maskubiya in Jerusalem, and she have been alone at the same room alone for 55 days. 55 days alone, and all the time have a stick or something. She told me that they passed 12 strip search, and she says was shaking, and she added at the same time in have been in Ramla prison, and after that in Sharon, and after that she moved here with the posta, the car we take the prison from there. It was take it to Damoon, and when she came to the Damoon, at the same time they came to have the strip search for her. You imagine what's for a young lady to happen. It's very difficult. And after that also she has nothing, and she can't be in touch, not with lawyer for 55 days, not with the family, not with anyone. And from this plantation, I salute the prisoners to continue the resistance against the occupation. So the Red Cross and all the international, also Amnesty, all the this community doesn't do anything for them. So it's now very, very difficult situation for them. It's really, really, about 12,000 prisoners, and also the beds now, it's about 5,200. So you imagine that most the prisoners without beds, most of them without clothes to change them, and also to have food only just little bit. So when I see them as a skeleton, I see some person before, they told me it's 90-60. So I told him, what's 90-60? He told me that you must, if you are weight the 90 kilo, you must be 60 kilo only. And I see very prisoners which I meet them before, and I met them now. I can't imagine how it happened for them. And also they told me that like the caves people, they with the hair, with the lot hair, and the hands, and very dirty, because they have the situation is very, very bad. So it's really very difficult, because when I visit today, for example, I visit the Damoon, and I see Amani, and I see also Amani and Tasneem. And Amani told me that 9 months don't cramp her hair. It's the same all the time, only by hand, because they don't have it. They can't have anything to do it. And also they don't have shampoo don't have sabun, don't have anything to be clean for them. Now I would just because Camille Abu Hnesh with us, I would like to take this opportunity and to congratulation our guest, my friend and recently freed Camille Abu Hnesh. I met him about more than 10 times in prisons last years, and finally he is now out in the sun. But even now the freedom is incompleted because he comes now from Palestine to Egypt, and he can't be go to home. He can't go to see the grave for his father. He died last year without saying hello to him. And that's what's going on for them. I met Camille many times in prison across the bars and spent hundreds of hours to conversation. We talk hundreds of hours all the time, and had the honor to having signed his novel Miriam at Amman Book Fair, and also the second novel, The Seventh Side, both in Amman and in Palestine, and also have the privilege of taking part of many works with him all over the world. So today, the flood Tufan and the Comte agreement have carried him out of the debates to prison into the open horizon of freedom. My warmest congratulations to Camille and all the comrades and all the prisoners who are released. Freedom for the prisoners and detainees in Israel prisoners soon as soon. Thank you for listening.
Thank you very much, Hassan. Before we go on to the next speaker, I'd just like to ask you, do all of the prisoners and all of the detainees, are they given counsel? Are they given a lawyer to represent them? For example, how does someone get you as their lawyer?
No, I'm volunteer. So I meet about 700 prisoner meetings all over the last 5 years. Now it's difficult for the most people to have a lawyer. So some of association in Ramallah give them the opportunity to have it. But for me as volunteer, I can't meet all of them. So I just a few hundreds of them.
How many volunteers are there like yourself? Or are you the only one?
I didn't meet anyone. I'm sorry.
Okay. Very good. Well, thank you very much. We can go now. Hopefully, we'll have time for more questions and answers at the end of this section. But we'll go on now to our second speaker, Gayeshel Andersland, who is a lawyer, activist, and member of the Palestinian Children in Israeli Military Prisons. He is also chair in the Committee for the Rights of the Children in the International Commission of Jurists. Gayer?
Thank you, Peter. Good evening. Yes, I'm an active lawyer, and especially because of my membership in its Norwegian campaign organization, Palestinian Children in Israeli Military Prisons. Of course, those children are my perspective for my talk here tonight. And I just want to start with a story. A 16-year-old boy was abducted by Israeli forces while searching for aid with his father and 25 other Palestinians the morning of September 11. This is according to documentation collected by DCIP, that is Defense for Children International Palestine. An Israeli soldier interrogated the boy, severely beating him after binding his hands and forcing him onto his knees. And the boy is telling, "He struck my forehead so hard that it split open and required stitches." After the interrogation, the soldier blindfolded the boy, and next morning, Israeli forces transported him and other abducted Palestinian children out of Gaza to the prison Said Tayman in southern Israel. There was a stop at the Karem Abu Salem crossing, where detainees were ordered to disembark and strip naked. Israeli soldiers dressed them into white coveralls and forced them to lie on their stomachs on the ground for an hour, during which soldiers kicked and abused them. The boy was then placed in a cell with Palestinian adults for 4 days before being transferred to a cell for children, which held about 7 of them. After this, he was subjected to another brutal interrogation, during which he was handcuffed to a chair with his hands bound behind his back and his legs bound to the legs of the chair. Each time he answered, "I don't know," to an interrogator's question, another interrogator beat
Guy, it looks like you are frozen.
Later, he was returned to a cell where rotten food and frequent beatings awaited him. He declined a haircut, which was required for all detainees, and Israeli soldiers placed him in handcuffs for a full week. But this is not an unique episode. For many years, the Israeli military authorities have violated Palestinian children's fundamental rights through arrest, interrogation, detention, and prison. And as you may know, there has been presented a lot of reports of documentation. UNICEF in 2013 had maybe the first report to bring the violations to public knowledge. It has lasted for long before 2013, but this report from UNICEF was very much, they became very much aware of it. And I can mention for you, and it's because of this report from UNICEF 2013, which was a main reason for why the Norwegian organization, which I'm representing, was established. The conclusion in this report was that the ill treatment of Palestinian minors in Israeli military detention centers is widespread, systematic, cruel, inhuman, and degrading. And in the same year, the United Nations Committee on the Convention of the Right of the Child, as you know, United Nations has a special committee which has a focus on every state party on how they live up to the convention, which they have all, except from USA, ratified. And this committee makes periodical reports of all the states, Norway, for instance, as well. And this report in 2013 was on Israel, and they concluded in very much the same way as the UNICEF report. And some of the findings I just repeat for you. The children are arrested in the middle of the night by soldiers shouting instructions at the family and taking them hand-tied and blindfolded to unknown destination. Systematically subject to physical and verbal violence, humiliation, painful restraints, threatening with death, physical violence, and sexual assault against themselves or family. Restricted access to toilet, food, and water. And in 2024, last year, this committee, United Nations Committee on CRC, had a new report on Israel. As I tell you, they have periodical reports. So one in 2014 and a new one in 2024. And it was the same, even worse. And the committee, I quote some of the committee's sayings, the committee expresses its deepest concern about the continued abduction, arbitrary arrest, often during the night, and prolonged detention of Palestinian children in the occupied Palestinian territories by the armed and security forces, including administrative detainees or unlawful combatants, mostly without charge, trial, or access to legal representation or contact with family members. And the committee concluded with strongly urging Israel to immediately end the arbitrary and administrative detention of children and release all Palestinian children, and ensure that the child justice system is applied to all Palestinian children and that they are not tried in military courts, and that they are not treated as adults because they are of so-called fighting age. Abolish the system of detention and the use of torture and ill treatment of Palestinian children at all stages of the judicial procedure. Israel is the only country in the world that systematically prosecutes children in military courts, which means rejecting the children their fundamental right to a fair trial. A military court is part of the military authorities, not an independent and impartial decision maker. The military court judges are active, duty or reserve officers in Israeli military, being loyal to the military authorities. By October 2025, there are 350 children detained in Israeli prisons. This is according to the latest data available from the Israel Prison Service. But this data does not include children who are detained in Israel military detention and interrogation centers. At these sites, there are no available data for the number of either children or adults detained. And 48% of the total numbers detained, that is 48% of the 350, that is 168 children, are held in so-called administrative detention. Administrative detention is imprisonment of individuals without charge or trial based on secret evidence which prevent contradiction. Administrative detention orders are issued by the Israeli military commander of the area or at a military officer delegated by the commander. It can last up to 6 months, but there are no limit to the number of times the administrative detention order can be renewed. The orders are approved by military court judges, which, as I just mentioned, do not meet international standards for independence and impartiality. It has, as I told, been grave violence for many years from Israeli authorities against Palestinian children. But it even worse, if possible, since October 7, of course, 2023. And summarizing what the children are up to, I mentioned, they are lacking adequate food and water. They are being subjected to beatings and verbal harassment. They are lacking access to medical care. They are being subjected to torture, including the use of solitary confinement, which is regarded as torture by United Nations Torture Committee. The International Committee of the Red Cross is disallowed visiting the Palestinian children detainees. And lawyers representing the Palestinian detained children face increasing barriers to do their job and are forbidden to passing simple messages from families to the children. Israel commit a deliberate violation of Convention of the Right of the Child, ratified by Israel. And I will not use the time now to quote everything, but you have Article 37 and you have Article 40 in the Convention of the Right of the Child, which is especially meant to how the authorities can treat children, which may have been breaking the law, but still they have special rights as children. And all the things which I mentioned for you, which Israeli military authorities do against Palestinian children, is in break with these articles. It's also they also break the 4th Geneva Convention, for instance, by moving the prisoners, the children from Gaza or from Palestine to Israeli prisons. And we also have many examples that the military authorities try to recruit the children to collaborate with Israeli military, which is also prohibited by the 4th Geneva Convention. And of course, the Convention against Torture is also extremely violated. And to quote Aya Abu Ekwatish from Defense for Children International Palestine, and that's making my conclusion and end of this small talk, it is clear that Israel's practice of child detention has nothing to do with the rule of law, justice, or security. It is an arbitrary system designed to physically remove, suppress, and stifle the development of Palestinian children, installing a permanent sense of fear and insecurity. Every day a child spends in an Israeli prison without charge is a day stolen from their safety, education, and childhood. Israel's escalating use of administrative detention against Palestinian children reflects a deliberate policy of repression and a complete breakdown of the rule of law. Defense for Children International Palestine calls on the international community to act decisively to end Israel's unlawful detention of Palestinian children and uphold their rights to liberty and dignity. I support this request as strongly as I can. Thank you for listening.
Thank you very much, Geir, for that painful report. I have just one question before we move on to the last speaker for this section. You were mentioning how many of these children are being treated as adults in prison. I'm wondering, and that the detention is 6 months, but it can go on indefinitely or renewed indefinitely.
Yes.
What is do you know the average length of how long a child is kept in prison once arrested?
I'm not quite sure on the average, but you have examples of children has been in administrative detention up to 2 years. Wow. In administrative detention. You see, you have this difference. Approximately half of the number is in administrative detention. The other half they got a verdict. They meet before the military court, and there is judges, and so they in a way they got a prison. They got a punishment, a prison for that differs. Most of them are arrested because of throwing stones. That's the typical. Many of them haven't thrown stones, but some of them have, and they can even get 20 years prison for having thrown stones against the military authorities. They don't get 20 years, but many of them get several years when they have been tried before a military court. That is bad enough, very bad. And during the interrogation, they have no lawyer. They have a lawyer during the hearing, which is have known possibilities to learn the case before he just show up in the court. But even worse is from a rule of law perspective, is the administrative detention, because the administrative detention they don't even get precise knowledge of what they are accused for. And if they have a lawyer, very, very often they don't have a lawyer. But if they have a lawyer, even the lawyer don't get the information. It's just told them that they represent a security risk in a way, and then they have been put in detention, as I said, for 6 months. And then it's renewed and renewed without any new precise accusation.
Okay.
Just to fulfill, I'm talking about children, but very many of the adults, Palestinian adults, are also put in administrative detention. Many more than 168. But my perspective is the children, and I think it's worse enough for the adults, but it's even worse for the adults, for the children.
Of course. Well, thank you very much. And then we'll move on to the last speaker of this section, Kamel Abu Hanish, who is a former Palestinian detainee and who is incarcerated in an Israeli occupation prison. So, Camille, if you could unmute yourself, please.
في البداية اسمحوا لي أن أقول مساء الخير للجميع، وأنا سعيد جدا بلقائي معكم هذا المساء. طبعا أنا الآن في لحظة أشبه بالحلم، لأني لم أتحرر إلا منذ حوالي 40 يوما، حيث أمضيت في السجون الإسرائيلية 23 عاما تقريبا، وكنت محكوما بالسجن المؤبد لمدة 9 مرات، يعني 9 مؤبدات كنت محكوم. طبعا أنا ولدت في قرية اسمها بيت دجن قضاء نابلس، وشاركت في الانتفاضة الشعبية التي اندلعت عام 87، وحيث كنت طفلا في ذلك الحين، حيث أعتبر هذا نضال إلى جانب أبناء شعبي في معركته التحررية التي يخوضها منذ أكثر من 100 عام. ومن ثم التحقت بالجامعات وكنت مناضلا في إطار العمل الطلابي، وشاركت في الانتفاضة الثانية التي اندلعت عام 2000، انتفاضة الأقصى، وكنت ملاحقا من قبل قوات الاحتلال وألقي القبض علي. اعتقلني الاحتلال سنة 2003، حيث حاكمني بالمؤبد لمدة 9 مؤبدات، وأمضيت منها 23 سنة إلى أن تحررت في 13 من أكتوبر هذا العام. طيب احنا نحن نريد أن نتحدث أو
لحظة شوي بالله. Guck mal, Peter, der Rashid wird ein bisschen zusammenfassen. Ne? Rashid kann ja zusammenfassen.
Nein, die Übersetzung läuft, alles gut.
Ja, weil einige sagen jetzt hier, dass sie keine Übersetzung sehen, weiß ich nicht warum. Also ist eigentlich gut übersetzt, ne?
Ja, aber ich denke nicht, dass wir das jetzt machen. Ich denke, die Leute müssen einfach auf diese CC-Signal eingeben und dann die Sprache auswählen und dann muss das funktionieren. Einfach, Entschuldigung, wenn ich störe. I'm sorry if I'm confusing. There's a symbol in the under there. There's 2 CC symbol. You choose this, you turn it on. It's a caption or Untertitel. It's caption. Then you choose your language and then you will see the translation of Ustaz Kamid. Yeah.
Yes.
أستاذ كميد تفضل.
نعم. إذا أمضيت 23 سنة في سجون الاحتلال، وخلال هذه السنوات يعني يمكننا أن نقسم السنوات هذه السجن إلى مرحلتين: مرحلة ما قبل 7 من أكتوبر ومرحلة ما بعد 7 من أكتوبر. قبل 7 من أكتوبر كانت ظروفنا أفضل بشكل نسبي، يعني لم تكن جنة السجون، ولكنها كانت أفضل، حيث كانت لدينا الكتب، كانت لدينا نستطيع أن نكتب، نقرأ، نستطيع أن نشتري من الكانتين، كانت لدينا ثياب، زيارات أهالي، كانت لدينا زيارات محامين، كنا نلعب الرياضة، كنا نناضل في سبيل تحسين شروط حياتنا داخل السجن. وطوال سنوات طويلة نجحنا في مراكمة إنجازات متعددة داخل السجن، وكنا نعيش حياة أكثر إنسانية، وكان بمقدورنا أن نواصل تعليمنا الجامعي، كان بمقدورنا أن نتحرك، كان بمقدورنا أن نشتري الطعام والثياب والأحذية ونمارس الرياضة كما ذكرت. وكانت الظروف ليست سيئة قياسا بما حدث معنا بعد 7 من أكتوبر. بعد 7 من أكتوبر، أي منذ بداية الحرب، انقلبت الأمور رأسا على عقب، وأستطيع أن أقول وبدون مبالغة أن ما حصل معنا داخل السجون ربما يشبه الممارسات التي كانت تمارسها السلطات النازية في معسكرات الإبادة في حقبة النازية، يعني معسكر أوشفيتس اللي يعني كان قائم في الحرب العالمية الثانية، ممكن كانت نفس الممارسات. كان هناك أولا سياسة التجويع، كان هناك سياسة تجويع ممنهجي، حيث سقط عدد من الشهداء في صفوف الأسرى بسبب الجوع. كمان أيضا الجوع تسبب بانتشار الأمراض الجلدية، عدة أمراض انتشرت في صفوف الأسرى، وكان في هناك يعني متعمدين، كانت السلطات إدارة السجون كانت تتعمد باختلاط الأسرى المرضى الذين لم يجري توفير العلاج اللازم لهم حتى تنتشر هذه الأمراض في صفوف الأسرى. وأيضا هؤلاء سقط من بينهم شهداء بسبب تفشي هذه الأمراض. أيضا جرى سحب كل منجزات، لم يبقوا لدينا أي ثياب شخصية. بالتدريج طبعا طوال سنتين كان هناك يجري سحب هذه الملابس، سحب الأدوات، كان ممنوع الحلاقة على سبيل المثال، أو قصاصة الأظافر، أو الصحون، أو المقتنيات الشخصية. حتى الكتب جرى مصادرة، حتى الكتب الدينية كانوا يصادرونها، يعني القرآن على سبيل المثال أو الإنجيل لبعض الأسرى المسيحيين كانت تصادر في بعض المحلات. ولكن كان كمان برضو يجري مصادرة الأدوات الكهربائية، لم يكن مسموحا لنا باقتناء الراديو على سبيل المثال، لم يكن متواجدا لدينا التلفاز ولا الصحيفة ولا غيره. كنا معزولين عزلة مطلقة، وممنوع أن نستمع للأخبار. وإذا خرج أسير إلى المحكمة كان يمنع ويحظر عليه أن يحضر الأخبار من المحامي. وكان إذا هناك أسير بلغ الأسرى الآخرين عن هذه الأخبار كان يحاسب. إذا كنا معزولين عزلة تامة عن الخارج، ولم يكن أول 6 شهور من الحرب يسمح لنا بالخروج خارج الغرف. إذا سياسة التجويع، سياسة الانتشار الأمراض، سحب المنجزات، كل شيء، كل الحاجيات اللي كانت موجودة عندنا كانت مسحوبة، ما سمحوا بوجود أي شيء. أيضا جرى حرماننا من زيارة الأهل، من الكانتين، من المشتريات، من التحرك، من لقاء المحامين، من الخروج. حتى في بعض مرات كان لا يسمح لنا بالاستحمام، كنا نستحم كل أسبوع أو كل 10 أيام. لم يعطوننا الملابس والثياب الداخلية، لم يسمح لنا بالحلاقة، حلاقة الرأس والذقن، إلا كل 2 أو 3. أما الضرب والاعتداء الجسدي والتنكيل والقمع فهذا كان يحدث كل يوم، وبطريقة مشينة جدا، وبطريقة الإذلال. يعني كانوا يتعمدون إذلالنا، كانوا يلقوننا على الأرض على بطوننا، وكانوا يدوسون على رؤوسنا، يعتدون علينا بالضرب. كانوا سقط هناك أيضا شهداء من الأسرى بسبب الضرب المبرح والوحشي الذي كان يتعرض له الأسرى داخل السجون. إذا كان في هناك يعني برنامج تنكيلي. وزير الأمن المتطرف الفاشي إتمار بن كبير كان يقف على لا يزال يقف على رأس هذه الوزارة، وكان يشرف بنفسه على هذا البرنامج. كان يأتي إلى بعض السجون ويخرج الأسرى أمامه، وكان يتبجح ويصدر الفيديوهات وهي منتشرة على وسائل التواصل الاجتماعي وفي الإعلام. كان يتبجح أنه يعني هو من ينكل بالأسرى، وأنه هو يعني سحب حقوقهم ومنجزاتهم. طوال 2 عام مثلا لم يسمح للأسرى بالطعام الجيد، اللحوم كانت ممنوعة، الأسماك كانت ممنوعة. يعني تفاخرت إدارات السجون بأن البرنامج الغذائي الذي يقدمونه للأسرى، الوجبات الطعام، عندما كانوا يفحصون يجدوا أننا فقدنا عشرات الكيلوغرامات من أجسادنا. أصبحنا حقل تجارب لمن يريد أن يعمل ريجيم على سبيل المثال. يعني كانوا يقولوا لا، يعني انه هاي افضل وصفه للرجيم اللي بده يعمل رجيم، هاي برنامج اللي احنا طبقناه على الاسرى الفلسطينيين، بامكانكم انكم يعني تطبقوا هذا. طيب اذا في هناك الاعتداء، التنكيل، القمع، ليل نهار. هناك فرق متخصصة قامت بتشكيلها إدارة مصلحة السجون للقمع الوحشي، كانوا يعتدون علينا بالعصي، بالرفسات، بالركلات، بالبنادق. أطلقت النار على عدة أسرى بالأرجل والأيدي. كانوا رش الغاز كل يوم، كانوا يعتدون علينا برش الغاز. كانوا يعصر إذا أحد أراد الخروج إلى المحامي لزيارة المحامي أو المحكمة، كانوا يستروا العينين بعصابة، يضعون العصبة على العينين، وكانوا يجبرون ويرغمون الأسير بالانحناء، يحني رأسه وظهره. وكانوا يربطوا الأسرى، أكثر من 20 أسير بربطوهم في بعض، وكانوا يجبرونهم على انحناء الرأس. وخلال الطريق يعني التي قد تصل إلى حوالي أكثر من كيلومتر مشيا على الأقدام، كانوا يعتدون على الأسرى بالضرب المبرح ذهابا وإيابا. إذا نحن نتحدث عن تنكيل يومي، ضرب، هناك خطر. نحن بهذه المناسبة أود أن أقول نحن تحررنا صحيح، يعني يمكن القول أن آخر يومين لنا في السجن كانت هي الأصعب، حيث جرى الاعتداء علينا قبل تحررنا بيومين أثناء نقلنا في الباصات في الحافلات. ولكن أقول الآن أن من خلال ما نعرف، من خلال اتصالاتنا بالأسرى المحررين واتصالاتنا بالمحامين الذين يزورون الأسرى، أن التنكيل والقمع تزايد بشكل كبير جدا بحق إخواننا الأسرى الذين تبقوا في السجن. هنالك خطر كبير ما لم نقف جميعا، مؤسسات حقوقية ومؤسسات دولية ومحامين ورأي عام عالمي ومناضلين، يجب أن نقف كلنا للدفاع عن هؤلاء الأسرى الذين يجري قتلهم ببطء. يعني هناك أقروا مؤخرا بالقراءة الأولى قانون إعدام الأسرى، واحتفلوا في الكنيسة الإسرائيلي بهذا الإقرار، بهذا القانون، بإقرار هذا القانون. هذا خطر. ولكن كمان برضو بنقدر نقول إنه يجري إعدام الأسرى كل يوم. هنالك أنا بعرف أكثر من 20 أسير من الممكن أن يسقطوا شهداء، لأن ظروفهم الصحية صعبة جدا. وعندما كانت تدخل وحدات القمع إلى الأقسام وإلى داخل الغرف، لم يكونوا يميزوا بين أسير مريض وبين أسير ليس به مرض، بين صغير في السن وبين كبير في السن. كان يجري الاعتداء على الجميع بشكل وحشي، هذا بشكل يومي. وأنا رأيت بأم العين أسرى جرى قتلهم بطريقة وحشية من خلال الضرب. رأيت بأم عيني انتشار الأمراض الجلدية التي من الممكن أن تودي بحياة الأسرى الفلسطينيين. إذا نحن نتحدث عن مسلسل كامل متكامل، ومن الممكن أن نكتب في الأيام والأشهر القادمة عن هذا الأمر لفضح الممارسات الصهيونية داخل السجون الإسرائيلية. هنالك مخاطر جدية، يجب أن ندرس بعناية ما يجري في السجون الإسرائيلية. ومن يريد أن يقارن ما كان يحدث في أوشفيتس أو مايدانيك المعسكرات النازية وما يحدث اليوم، يجب أن نوثق كل حالة، وهذه دعوة علنية للجميع أن يوثقوا هذه الحالات ويجمعوا المعطيات. ما يجري في السجون الإسرائيلية غير مسبوق. نحن صدمنا، يعني نحن أمضينا عشرات السنين داخل السجن، وبالتالي ما رأيناه ما بعد 7 أكتوبر وقبل 7 خلف لدينا صدمة كبيرة. حتى الأسرى الذين أمضوا أكثر من 40 عام داخل السجون وعايشوا مرحلة السبعينيات والستينيات، ممن يعني كانوا يترددون على السجون، قالوا لنا أنه لم يسبق، حتى في ظل هذه الظروف التي كانت قاسية في سنوات الستينيات والسبعينيات. ولكن اليوم السلطات الإسرائيلية معنية بالقتل. هم يعلنون أن قانون الطوارئ هو ساري المفعول، وبالتالي يشجعون السجانين على فعل ما يمكنهم فعله بدون محاسب، بدون حسيب ولا رقيب. وهؤلاء بالمناسبة يجب أن نتحدث أيضا عن السجانين الذين يجري إجبارهم وتشجيعهم من خلال رفع مرتباتهم وأيضا رفع رتبهم. كلما اعتديت على الأسرى، كلما أمعنت في إهانته وإذلاله، كلما كان أمامك فرصة للترقي في السلم الوظيفي داخل. انظروا كيف يجبرون هؤلاء السجانين الذين كانوا قبل 7 أكتوبر وناس عاديين، يعني ما كان في هناك يعني حالة عدائية شديدة ما بين السجين والسجان، كانت علاقات عادية سجين وسجان. ولكن أن يجري إجبار هؤلاء السجانين وتشجيعهم على الإمعان في التنكيل والإذلال والضرب والاعتداء الجسدي والشتم، يعني كانوا يشتموننا بطريقة مفزعة. إجبار السجانات أن يشتمن الأسرى بطريقة مفزعة بكلمات نابية، كانوا يتعمدون على سبيل المثال شتم الذات الإلهية أثناء الأذان، أثناء الصلاة كانوا يشتمون الذات الإلهية. كان ممنوع على سبيل المثال إنه حدا يأذن، إنك بدك تصلي صلي بس ممنوع صوتك يطلع. وكانوا يعاقبون الأسرى عندما يرتفع صوتهم أثناء الصلاة، كانوا يهاجمون الغرف ويقولوا أنتم تتعمدون بإطلاق صرخات الله أكبر، وهذه بالنسبة لنا تعتبر يعني تحريض. انظر كيف يعني تحولت الظروف داخل السجن. صدقا عندما تحررت في 13 من أكتوبر، نحن دخلنا في فصل الخريف وهناك برد، لا يوجد أغطية لدى الأسرى، لا يوجد ثياب، كانوا يتقاسمون الثياب التي يعني هي قليلة أصلا، لا يوجد إلا ثياب السجن البنية، بنية اللون فقط، مسموح للأسير باقتناء زي الأسرى فقط لا غير، بعد سحبهم بالتدريج لكل الثياب ولكل الأغطية الشتوية. يعني كمان برضو على سبيل المثال كانوا يجبرون يعني قصاصة الأظافر، يعني أنت بدك تقص أظافرك، كانوا يجبروا الأسرى أنه ما في عندنا قصاصة أظافر، قصوهم في أسنانكم. فعلا كان الأسرى يقلموا أظافرهم بأسنانهم أو يعمدوا على حف هذه الأظافر من خلال الجدار. يعني إذا كان في بقعة خشنة شوي فكانوا بحفوا أظافرهم لمدة أكثر من ساعة، ساعة ونص في الجدار. إذا إحنا نتحدث عن ممارسات تنطوي على حالة مرضية، لأن من يمارس هكذا أفعال هو مريض. يعني كانوا يتلذذون بطريقة غريبة جدا بتعذيب الأسرى، كانوا يجبروننا على الاستلقاء على بطوننا في الساحة لساعات طويلة في الشمس، والقيود تكون مشدودة على سواعدنا، وكان يتألم الكثيرين، وكان جزء من الأسرى يفقد صوابه
I'm
ويفقد
sorry
وعيه.
to interrupt, but and as painful as this is, I have to ask you to conclude because we're a little bit behind. So if you can perhaps just conclude what you're saying, and we can hopefully come back to for you to say more about this.
يعني نختصر القول أن يجب أن تتركز الأنظار نحو السجون الإسرائيلية حاليا، أن يجري فضح ما يجري مع الأسرى الفلسطينيين، وأيضا ندعو إلى دراسة هذه الظاهرة ما يجري حاليا، يعني من ناحية أكاديمية ومن ناحية فكرية يجب أن ندرسها. يعني لا يكفي أن نقول أن الممارسات النازية التي كانت سائدة في معسكرات الإبادة النازية كذا وكذا، ونعفي ونصور إسرائيل وكأنها دولة ديمقراطية بين قوسين. لا، الإسرائيليين أنا برأيي تفوقوا على النازيين في هذه الممارسات، ونحن نشجع إلى تعميق الدراسة لهذه الممارسات لنفهم طبيعة هذه الدولة كيف تفكر، وطبيعة الأشخاص الذين يقودون هذه الدولة كيف يفكرون، وما هي منطلقاتهم، وأيضا دراسة المجتمع الذي تتفشى فيه الفاشية وتتفشى فيه الروح الإجرامية. ما حدث في قطاع غزة شيء غريب ومذبحة رهيبة جدا يندى لها الجبين. كيف يمكن الدفاع عن ما جرى في غزة؟ ماذا يمكن الدفاع عن النفس؟ إسرائيل تدعي أنها تدافع عن نفسها، يجري تدمير البيوت فوق رؤوس ساكنيها. صحيح أن الأسرى الفلسطينيين لم يحدث لهم كما حدث في غزة، المقارنة يعني مش صحيح أنه، ولكن جرى التنكيل بنا، جرى تعذيبنا، جرى مصادرة حقوقنا، جرى يعني قتل الكثير من الأسرى من خلال هذه الممارسة. أكتفي بهذا القول لأن الشهادات كثيرة ومتعددة، ولكن يجب أن نقف مع الأسرى الفلسطينيين الذين يواجهون وحدهم هذه الممارسات ضدهم.
Thank you very much for reminding us all very directly why we are here and why we have to continue with this work to bring an end to what's going on in Israel. We're going to move straight on to our next speaker, Abdelhamid Siam, who is a New York-based United Nations independent expert.
Thank you so much. I'm very glad to be with you this evening, and I hope I can contribute to this important debate about the situation in Palestine, especially in reference to the Palestinian prisoners. My talk is going to be focused on international law. I cannot speak more eloquently than my brother Camille, who spoke about it, or my brother Hassan about the situation in the prison. But I want to ask these following questions. First, is the Palestinian a distinguished people, a distinct people? That's one. And second, is Gaza, West Bank, and East Jerusalem occupied territories? And if they so, what is the situation of the civilians who are living in those areas? Does international humanitarian law apply to these territories? And does Israel recognize that the applicability of international humanitarian law in these territories? And if they don't, what does international law say about it? And the other thing, if the Palestinian people is a distinct people and they are living in occupied territories and this occupation is illegal, then by law, resisting this illegal occupation becomes legal. And if the resistance is legal, then the occupying power, by the power of international law, they're supposed to treat those who are resisting the illegal occupation as prisoners of war according to the fourth and third, especially third Geneva Convention, which deals with the prisoners of war. So we have to look at the concept of the idea. I mean, we can talk about the torture and we can talk about killing and the negligence, medical negligence forever. It's volumes and volumes. I want to address that issue, the law. First, regarding the Palestinian, it has been established that the Palestinian is a distinct people. It's a people. There is a geographical area that manned by this people. The League of Nations decided that there is a people called Palestinian people, and there is Palestine. And the League of Nations classified Palestine as a level A. That means it's close to be qualified to rule itself. Palestine at that time has export, has industry, has colleges, has sport teams, has railroads. It's a complete, it's a society, a complete society and a distinguished country. It's just the League of Nations said, oh, they're so close to rule themselves. And in the after in the recent history, the General Assembly Oslo, in its resolution 3236, decided that the Palestinian people have inalienable rights. Decided that this is a distinct people and they have inalienable rights, which means independence. They have the right to have a self-determination. They have the right to have independent state of their own, and they have the right to return to their homes, which they've been expelled from it. In 1997, the General Assembly voted if the Fourth Geneva Convention applies to the Palestinians. There was so much resistance to that resolution. However, that resolution has passed by 117 countries in favor. Only 2 countries voted against it, which is the US and Israel. So in 2011, UNESCO recognized Palestine as a state. In ICJ, in July 9, 2004, in its legal opinion about the separation war, which is a very long opinion, I mean, it's a big book, it talks about the Palestinian as a distinct people entitled to self-determination. And these territories that occupied by Israel in 1967, it belongs to the Palestinian people. It's not, as Israeli claimed, that it belongs to no one, and it was occupied by Jordan or by Egypt. The ICJ rejected that logic and decided that this territory belongs to the Palestinian people, and they decided in that opinion that these are occupied by Israel, and this is illegal occupation. Israel should not continue its legal occupation. Again, I was to jump a few years later, and in July 19, 2024, the ICJ presented a very important opinion, which saying that this illegal occupation should end within a year. Israel, that's the ICJ opinion in July 19, 2024, that Israel should terminate its occupation. The settlements are illegal, settlers must be moved, and the Palestinians should be compensated for that. So we come to that, put it together, that the Palestinian is a distinct people. The territories that Israeli occupy are illegal occupation. Israel was requested to relinquish this occupation, to end it, not from now, but from 1967. Resolution 242 exactly said Israel must withdraw from these territories that it occupied in recent conflict. It didn't say in general, it's in recent conflict. So 242 also called on Israel to withdraw. Israel did not withdraw. Israel illegally built settlements in these occupied territories, which belongs to a distinct people called the Palestinian people. Therefore, now we come to the important issue that resisting this occupation becomes legal. Why? Because that the UN said, the international law said, in 1960, the UN General Assembly passed an important seminal resolution, which is 1514, which grants peoples and territories under foreign domination, under occupation, under colonial power, the right to self-determination and to end that occupation with all means. Even the Palestinian people, there is a resolution which talks about the right of the Palestinian to resist occupation by all means, according to within the conformity of the UN Charter, the resolution 3236 and many other resolutions. It talks about the right of the Palestinian people to resist occupation. If the Palestinian and the distinct people, their land is occupied illegally, the international law says that this occupation must end, and the occupying power refused to do that, and they continued to exercise the illegal practices in these occupied territories, especially changing the demographic composition of this territory by bringing their own population into the occupied territories, which is illegal according to ICJ. and taking Palestinian and putting them in Israeli jails in their territory, which is illegal also according to Third Geneva Convention, then the Palestinian people has the right to resist. So we shouldn't be shy away from telling that the Palestinian has the right to resist, which is something missing from all the speeches of Arab delegates and many delegates in the UN when they talk about the suffering of the Palestinian people. And the Palestinian ambassadors start crying about the practices of Israel and killing children, killing women, destroying schools. Yes, but he had not said one time that the Palestinian has to resist occupation. We shouldn't shy of that. We should. We're following the law. So the UN told the Palestinian in Resolution 3236 in 1974, you have the right to resist. And the Palestinians did that. So anyone who was arrested because he or she resisting occupation, then they are practicing their own right. And Israel is obliged by the law to treat them according to international humanitarian law, which is embodied in the Third Geneva Convention. Third Geneva Convention deal with prisoners of war from the moment they are arrested to the moment they are released, or if they pass away in the prison. It talks about their food, it talks about their clothes, it talks about the environment, it talks about how they're treated. I don't want to give you, just go look at this 146 articles in this convention. It does not leave any loophole in that convention, which has been applicable to the Palestinian people. From that point, I want to say that Israel is committing all these crimes because it's not following the law. And I just want to mention a few which has been, because it's not following the law, so all the detention of people without a trial is illegal. It's a crime. Every child under 18, when they are arrested, it's illegal, and it's a crime against humanity. Putting a child in a martial is also another crime, should be not forgotten. And torture and medical negligence is also illegal and should be tried in international tribunals. Now, I want to say that ICC, the International Criminal Court, had betrayed the Palestinian people. They never talked about prisoners. They didn't. 2 years of genocide, they issued just 2 arrest warrants, two. One against the prime minister and one against the defense minister. It was first issued when Karim Khan on May 20th, 2024, said, asked the preliminary court to issue these arrest warrants. They were issued on November 21st, 2024. And then he was accused of sexual harassment, which is very false. It's truly false. ICC, all their the judges were put under US sanctions. And even Francesca Albanese was also denied, prevented from coming to present her report to New York. And the ICC did not say anything after that. Thousands of Israelis committed war crimes. And they're proud of it. They take videos of themselves. Everyone saw what happened in this Timan detention center, the raping of young men and women, everyone. And even those, when they put a trial, which is very staged, completely staged, and those 7 people coming to trial, people were cheering them, cheering them. Yeah, this is the situation that what happened in Israel. Israel, as my brother said, as a society, in the vast majority, are moving toward that kind of fascist ideology. And when you hear from the defense minister, there is no innocent in Gaza. We are fighting human animals. That means they are justifying to destroy and completely obliterate the Palestinian people. So we shouldn't shy away from saying the Palestinian resistance is legal. What is illegal is occupation and the occupying power. Thank you very much.
Thank you very much, Abdulhalim. I understand you're having a new interview very shortly. I hope you're able to return to us later on after the other interview.
I'll stay with you for like at least 19, 20 minutes, and then maybe I'll go out and come back. Just do a 10, 15 minutes interview with Al Jazeera and come back.
Thank you.
But it's too early.
Okay. So we'll go on to Jan Furman, a longtime human rights lawyer who has most recently been the lead prosecutor at the International People's Tribunal for Palestine, which took place in Barcelona and concluded just 3 days ago. Jan?
Thank you, Peter. Good evening, everybody. First of all, much of what I would have liked to say has been said by the previous speaker, so I will try to revisit some of the points he made and try to put them in perspective a little bit. I will speak a little bit about the legal framework. Not that much. I don't want to impose upon you a legal lecture or a lecture on law, especially not at this time of the evening. But there are some points of the legal framework and discussions on the legal framework which are of uttermost importance for the solidarity movement, because there are different ways to approach the problem of Palestinian prisoners, and they have different political implications. And so I will speak about the legal framework, but from the point of view, how should we approach this in relation to the broader framework. And then the second point I would like to discuss is, of course, because the title of this event refers to international courts, which means in the broad sense remedies out of Israel, because we know that the remedies in Israel are inexistent. Remedies in other parts of the world or other mechanisms that can be used as a remedy for the violations which in relation to prisoners, which I will try to discuss with you. The first thing I would like to say in relation to these enforcement mechanisms is that the enforcement mechanism for international law is people's solidarity action. There is no international police, international courts, as was rightly said by Abdelhamid Siam. International courts have very limited possibilities, and if they have the will to do something, then they are immediately under sanctions, as we saw in relation to the very timid actions undertaken by Karim Khan in relation to the war in Gaza, where he did not even mention genocide. That triggers a very important reaction against the International Criminal Court, against him personally, against the judges. So it's not courts, it's not international institutions or organizations, and it's not states we should count on to enforce international law. International law has always been enforced by people's action, pushing these institutions, pushing states to take action against violations of international law. And so I think we should be very much aware of that. We are the enforcement mechanism, nobody else. And of course, courts and national courts throughout the world, international courts, can be tools in our struggle for justice and in our struggle against the violations of the rights of the Palestinian prisoners. But we should not be naive and rely on them and hope that they will solve the problem. We have to do the work. I will, however, get back to some of the ways we can use these tools in my talk about the legal framework. First of all, the Palestinian prisoners should benefit from multiple layers of protection. Of course, international human rights law applies to all Palestinian prisoners. And for example, the international Article 7 of the International Covenant on Civil and Political Rights, which actually says that no one should be subject to torture or to cruel, inhuman, or degrading treatment or punishment, I think is violated bluntly, openly, and very seriously in relation to the Palestinian prisoners, and, for example, to what we heard earlier from the Palestinian prisoners who actually were subject to these measures of torture, cruel, inhuman, or degrading treatment. However, there is no international court that has jurisdiction over violations of these provisions, unless, and I think that is probably an instrument we should use, unless in relation to torture. The Torture Convention does create universal jurisdiction over violations of the Torture Convention, which means that actually not international courts, but national courts throughout the world of all countries that did ratify the Torture Convention should have jurisdiction and have jurisdiction over violations of the Torture Convention wherever in the world by whomever committed. And so I think we have a first instrument there where we can try to use in our national jurisdictions the violations committed by Israel of the Torture Convention in relation to the prisoners. We have maybe a first instrument there, or a first forum we should use. And again, basically, I'm quite sure that when a Belgian court would be looking into those violations, of course, that will not stop the torture in Israel, but it can be an instrument, it can be a lever for the people's movements throughout the world, the solidarity movements, to strengthen their fight against the torture in the Israeli prisons. And so prisoners, all prisoners are protected by, or should be protected by, the human rights, by international human rights law. But very rightly, Abdelhamid Siam said that there is another layer of protection that I would say comes over this general protection of human rights, which is international humanitarian law. And the reason for that, of course, is that international humanitarian law applies to armed conflicts, it's actually the law of war, in the sense that the international humanitarian law defines the rules of how war can be conducted, or an armed conflict can be conducted, and especially how civilians should be, civilians, but also combatants that are no longer in a position to participate in the war, should be treated by the warring parties. Israel is extremely, I would say, not reluctant, but they refuse categorically to consider the Palestinian prisoners as protected by international humanitarian law. And that is, of course, because Israel practices a policy of criminalizing everybody who is fighting the occupation, the illegal occupation, as a criminal, a terrorist, a common criminal, and wants to prosecute people under their courts, which is absolutely forbidden by international humanitarian law, for acts of resistance. International humanitarian law, it was already mentioned by Abdelhamid Siam, the Third Geneva Convention, which is ratified by Israel, protects actually prisoners of war. It means combatants who participated in the hostilities that are then taken prisoner on the battlefield. And I think one can consider the problem from 2 points of view. The Article 4 of this Third Geneva Convention is defining who should be considered as a prisoner of war. And of course, first of all, it's members of the armed force of a party to the conflict, as well as members of militias and volunteer courts forming part of such armed forces. So if we consider that Palestine is a state, which of course I personally think, and which a majority of the countries of the world now for a very long time have been thinking, then of course Palestinian fighters are members of armed forces, although these armed forces are not organized in a traditional way, but are members of armed forces of a party, of a state party to the conflict, the state of Palestine against the state of Israel. But even if you consider from the point of view, even if you deny Palestinian statehood, then still the article, the same for Article 4, but now paragraph 3, said that should also be considered as prisoners of war, members of other militias, and members of other volunteer corps, including those of organized resistance movements, with a series of conditions which I'm not going to inflict upon you. You can read this Article 4 too. But even those who do not consider Palestine to be a state and the resistance fighters to be part of the armed forces of the state of Palestine, even those should recognize that it's a resistance movement and that the fighters of that resistance movement are recognized under Article 4 of 2 of the Third Geneva Convention. Now that has a series of consequences, very practical consequences. The first practical consequence is that the only right a party to an armed conflict has when it takes prisoners of war, which is individuals that have been participating in the hostilities, the only right they have is defined by Article 17 of this Third Geneva Convention. And that is to ask for the surname, the first name, the rank, the date of birth, the army and regimental and personal or serial number, and equivalent information. Beyond that, no questioning, no trial, nothing. You can't put on trial individuals because they participated in an armed conflict. Unless, of course, when they commit war crimes or in that armed conflict, then you can try them for war crimes. The majority or a large number of Palestinian prisoners are probably to be considered as resistance fighters, and therefore they're putting them on trial, sentencing to life sentences for what are actually acts of war is completely illegal under the international law. And I think we should emphasize that, because the fact that Israel in such a hard way denies the fact that some of these Palestinian prisoners are prisoners of war is actually because they deny, as was very rightly said by Abdul Hamid Siam, the right to resistance to the Palestinian people. And so it's an important point regarding the Palestinian prisoners to fight for their status as prisoners of war, because it is at the same time the expression of our fight for the right of Palestinians to resist the occupation. And so you can't speak about Palestinian prisoners without dealing with this topic, which is of course different from the way they are treated, from the way they are, from all the horrors we've heard and we know. It's a principled point, but it is actually the way in relation to prisoners to defend the right to resist the criminal belligerent occupation of Palestine. A second thing then is that, which is also denied by Israel, the Fourth Geneva Convention protects civilians in a situation of war. And that has also been mentioned by Geert Landersland. An important point there of protection is that the Israeli, actually the Fourth Geneva Convention bans the possibility to deport, to evacuate individuals, civilians that are, I would say, belong to one of the warring parties, to evacuate them from the territory. Article 49 of the Fourth Geneva Convention says that individual or mass forcible transfers, as well as deportations of protected persons from occupied territory to the territory of the occupying power or to any other country, occupied or not, are prohibited. Which means that the practice of transferring Palestinian prisoners to Israeli prisons is actually an illegal practice under the Fourth Geneva Convention, and is only possible because the Israelis precisely deny the fact that they are in an armed conflict with Palestine, and that therefore the population, Palestinian population, civilian population, is protected by the Fourth Geneva Convention. And so again, raising this point is not only a matter of human rights, it's not only a humanitarian matter, it is a principled political matter in relation to Palestinian prisoners. The violations committed by Israel by moving prisoners to the Israeli territory is actually the politically underlying stand is that there is no war and that there is no legitimate resistance against the occupation. And so I think in our defense of prisoners, we should pay particular attention to these points. Then I would like to say a few words also about the practice of administrative detention. I think, of course, in situations of armed conflict, the parties to the armed conflict do have some rights to practice forms of administrative detention. That is a consequence of the fact that there's a situation of war and that particular security concerns can be dealt with administrative detention. But there are a series of rules. You can't do whatever you want in the framework of this administrative detention. And my position is that the way Israel is practicing administrative detention is so far away from what is allowed eventually in a situation of war that it's actually practicing not administrative detention, but completely arbitrary detention under the pretext of administrative detention. Very, very strangely there, the administrative detention is then justified by security concerns, which then should imply that there is an armed conflict indeed going on. But that part, of course, the Israelis will not take it. They will just take the practice of the administrative detention. I think that we should say that in the present situation, in the way it is practiced, the administrative detention is in fact a totally arbitrary form of detention, which is not allowed neither by international human rights law or by international humanitarian law, and is even amounts to a war crime. And maybe even we should say that it's a form of collective punishment imposed upon the Palestinian people, which in the situation of armed conflict as we are facing in relation to Palestine, which is actually a war crime. Now, violations of the Third and the Fourth Geneva Conventions, and then I get back to the question of remedies and fora, where these remedies could be actually, that have jurisdiction over these remedies. There are a series of situations in which war crimes and thus violations of the Third or the Fourth Geneva Conventions are that courts out of Israel do have jurisdiction over these crimes. The principle of universal jurisdiction is enshrined in the Geneva Conventions. However, we all know that attempts to apply the universal jurisdiction have been cumbersome. Some countries tried to apply universal jurisdiction, including my country, Belgium, and including to some of the crimes committed by Israel and Israeli officials. And it is cumbersome because the tendency throughout the world, in Spain, in Belgium, has been to restrict, Germany has been to restrict the application of of universal jurisdiction as soon as it conflicts with other political and diplomatic interests. And of course, in relation to Israel, it does that also almost by definition when it comes to the Western countries. However, I think there is somehow I would say, a specific element in relation to Israel, which I think we need to pay attention to, and which is interesting in the sense of creating jurisdiction over crimes committed by Israeli officials against Palestinians, including against Palestinian prisoners. And that is that most countries do have jurisdiction over their own nationals participating in such crimes. And in Israel, we have this particular situation that many of the soldiers actually have dual nationality, have both Israeli nationality and another nationality. And so in relation to the war on Gaza, organizations, some of which you might know, the Hint Rajab Foundation, for example, with which I am working here in Belgium, are trying to bring cases to national courts based on this principle of active personality, active personal competence, which means if a Belgian who a Belgian Israeli has committed war crimes in Gaza, for example, then we're not talking about universal jurisdiction, but we are talking about normal Belgian jurisdiction. Belgium has jurisdiction over Belgians committing crimes abroad. There are some limiting conditions, but it's actually much broader. It offers much broader possibilities than the universal jurisdiction. And I think from the point of view of the remedies, we should carefully look into this, because I'm quite sure that if we look carefully at it, we will also find people who are participating in the violations committed against the Palestinian prisoners who do have double nationalities. And that opens a series of possibilities to actually seize courts and jurisdictions in different parts of the world. But again, and I want to conclude with that, I'm not naive. Even if we succeed to bring cases on this basis in relation to Palestinian prisoners to national courts in European or other countries, it is still the people's solidarity movement that is decisive to know whether these cases will go further, will be able to develop. And at the end, if a case comes to a conclusion and there is a conviction of a war criminal, whether that will be effectively implemented, yes or no. This last part, whether the cases will go to the end, and whether then when a decision has been taken, whether it will be implemented, will entirely depend on our action and our movement, not on the will of the states, because we are quite sure that, or international organizations, because we are quite sure that the will there will not be present. So we are the mechanism of implementation of international humanitarian law and human rights law in relation also to the situation of the Palestinian prisoners. That was a few additional remarks I wanted to make in relation to what Abdelhamid Siam said, and with which I completely agree.
Thank you so much, Jan, and thank you for reminding us that it's very important to think globally but act locally, and that everything we do on the ground has some impact. We are a little bit behind schedule, so I just want to go ahead now with our third and final section. and hopefully we'll have time for some questions and answers at the end. Our next speaker is Khalid Al-Shuali, who is a founding member of the legal team representing Palestinian victims at the International Criminal Court. So, Khalid,
Yes.
yeah, very good.
Thank you very much for your introducing. الشكر الكثير للجميع، جميع الزملاء الحاضرين وأيضا الزميلات أيضا. إذا أنا أريد أن أعقب على ما قيل، لأنه قيل الكثير من الكلام حول المحكمة الجنائية الدولية، المحاكم، القضاء الدولي. والحقيقة أنه هناك ملاحظات قد يتسع صدر البعض لها وقد لا يتسع صدر البعض لهذه الملاحظات. لكن أنا أقول بأنه المحكمة الجنائية الدولية مثلا، إذا أردنا أن نذهب إلى المحكمة الجنائية الدولية بغض النظر هل هي قامت بالدور الفعال المنوط بها كمحكمة تم التعارف على اختصاصها بأنها محكمة جنائية ضد مجرمي الحرب وضد المجرمين الدوليين. نحن نذهب بأنه القرار الصادر في فبراير 2021 قد نصب من هذه المحكمة أول قضاء دولي أو قاضي جنائي دولي لفلسطين منذ أكثر من 100 عام. نحن نعلم بأن فلسطين دخلت تحت الانتداب البريطاني في سنة 1921. فلسطين دولة بالمعنى الدولي. فلسطين كانت دولة وما زالت دولة، ووجود الاحتلال على بعض أجزاء من هذه الدولة الفلسطينية التي امتدت، الدولة الفلسطينية التاريخية التي امتد وجودها منذ نهاية الحقبة العثمانية، نستطيع أن نقول بأنها دولة بالمعنى والمفهوم المتعارف عليه دوليا. ولذلك يعني وجود إسرائيل على جزء من هذه الدولة لا يعني أن الدولة قد انتهت وأنها ذابت وأنها قد انتهت. لا، الدولة موجودة. ولذلك يعني أقول بأن الدولة ممتدة من سنة 1921 إلى يومنا هذا. صحيح أن هناك الاختصاص الجنائي الدولي قد انتقل من الدولة الفلسطينية إلى محكمة الجنايات الدولية بالقرار الصادر في 2021 من محكمة الجنايات الدولية، والتي اعترف في هذا القرار بأن فلسطين هي دولة بمعنى النظام الأساسي لمحكمة الجنايات الدولية، واعتبر بأن الاختصاص المنوط بالمحكمة الجنائية الدولية يمتد إلى فلسطين كاملة، بالمفهوم الصادر بعد 1948، أي أنها الضفة الغربية وقطاع غزة، الضفة الغربية بما فيها أيضا القدس الشرقية. ونحن نعلم بأن أيضا العديد من القرارات الدولية التي صدرت في هذا المضمار قد أعلنت بأن فلسطين موجودة وأن الشعب الفلسطيني له حقوق. من هذه الحقوق هو حق تقرير المصير، وأن الحقوق التي للشعب الفلسطيني لا يمكن أن تنتهي وأن تذهب وأن تذوب. هذه الحقوق ثابتة للفلسطينيين كأفراد وكمجموعة بشرية أيضا تعيش على هذه الأرض الفلسطينية. ولذلك يعني القرارات الدولية الصادرة سواء عن مجلس الأمن أو عن الجمعية العامة لهيئة الأمم المتحدة قالت بأن جميع الإجراءات التي تقوم بها دولة الاحتلال الإسرائيلي في الضفة الغربية بما فيها القدس الشرقية وقطاع غزة هي إجراءات باطلة. يعني الآن أو بعد غد أو بعد غد هذه الإجراءات سوف تنتهي وتذوب، ولا يمكن أن تعطي أثر على الشعب الفلسطيني أو على الأرض الفلسطينية. لذلك يعني هؤلاء الفلسطينيين الذين يعيشون على هذه الأرض لهم حقوق، وهذه الحقوق ثابتة بموجب الاتفاقيات كما ذكر الزملاء، بموجب الاتفاقيات أيضا اتفاقيات جنيف الثالثة والرابعة، بالإضافة إلى البروتوكول الأول للملحق باتفاقيات جنيف، وخاصة المادة 4 والمادة 96 من هذا البروتوكول أيضا، الذي يقول بأنه أيضا حركات التحرر الوطني يمكن أن تكون جزء أيضا ومن هذا النسيج الوطني الذي قد يدخل أيضا في نطاق أحكام اتفاقيتي جنيف الثالثة والرابعة. لذلك يعني احنا نقول بأنه الأسرى الفلسطينيين سواء كانوا أسرى بمفهوم اتفاقية جنيف الثالثة وبمفهوم اتفاقية جنيف الرابعة، هم أيضا مشمولين بهذه الحماية الدولية، وسواء كانوا محاربين أو سواء كانوا مدنيين. الفلسطينيين المعتقلين والفلسطينيين الأسرى المحاربين هم مشمولين بهذه الحماية، ولا بد أن يتم هذه الحماية للفلسطينيين. لذلك نحن توجهنا إلى محكمة الجنايات الدولية منذ سنة 2010، ونحن نعمل أمام 2008-2009 أمام المحكمة الجنائية الدولية من أجل تثبيت الحقوق الفلسطينية، من أجل الدفاع عن الحقوق الفلسطينية. ونحن نعلم بأن هناك قرارات صدرت في هذا المضمار. هناك كما ذكر الزملاء أيضا مسألة الرأي الاستشاري لمحكمة العدل الدولية في 2004، ونحن نعلم بأن هذه الآراء الاستشارية التي صدرت عن محكمة العدل الدولية في 2024 و2025 في قضية استمرار الاحتلال الإسرائيلي وفي قضية اليونروا واحترام المؤسسات الدولية أيضا ثبتت مجموعة من الحقوق للشعب الفلسطيني. وهذا يعني من الأمور المهمة جدا والتي يجب أن ينبني عليها عمل مستقبلي. نحن نعلم بأن الأسرى هم موضوع مهم جدا في القانون الدولي، ولا بد أيضا للسلطة الفلسطينية أو للدولة الفلسطينية. السلطة الفلسطينية هي مشروع على الدولة الفلسطينية. الدولة الفلسطينية يجب أن تقدم أيضا وأن تضغط على الجمعية العامة لاتخاذ أيضا إجراء في مسألة الحصول على رأي استشاري في في محكمة العدل الدولية في قضية الأسرى. هذه القضية مهمة جدا، ولا بد للجميع أن يعمل على الضغط على المجموعة الدولية لتبني قرار من الجمعية العامة للذهاب إلى محكمة العدل الدولية من أجل البت في قضية الأسرى، وخاصة أننا أمام شيء مهم جدا، هذا القرار الذي ممكن أن يصبح قانونا لدى دولة الاحتلال الإسرائيلي في مسألة إعدام الأسرى. فهذا القضية مهمة جدا ولا بد من العمل عليها. المحكمة الجنائية الدولية وإن أصدرت إلى يومنا هذا فقط يعني مذكرتي اعتقال في حق نتنياهو وجالنت، إلا أنها تعمل. والحقيقة في تواصلنا نحن الفريق القانوني الذي يعمل لدى المحكمة الجنائية الدولية، ولدينا أكثر الآن من 2000 تقريبا يعني موكل ضحية لدينا أرادت أن تلجأ إلى المحكمة الجنائية الدولية. هذا الإجراء مهم جدا، ولدينا مجموعة كبيرة الآن من الأسرى تريد أيضا أن تذهب إلى المحكمة الجنائية الدولية، وفي التواصل مع سواء قسم الضحايا في المحكمة الجنائية الدولية أو في التواصل مع دائرة أو مكتب المدعي العام في المحكمة الجنائية الدولية. وجدنا أن هناك تجاوبا، وهناك أيضا كثير من الإجراءات المفتوحة أمام مكتب المدعي العام، خاصة في التحقيق وإجراءات التواصل مع الأسرى الفلسطينيين. وشخصيا قد ساهمت في التواصل مع مجموعة من الملفات مع دائرة المدعي العام في المحكمة الجنائية الدولية. وهذا يعني أيضا يسجل للمحكمة الجنائية الدولية أن هناك رغم ما يقال بأن القانون الدولي ليس له لا أنياب ولا أظافر يستطيع من خلالها أن يطبق الأحكام القضائية سواء الدولية أو القرارات الدولية الصادرة عن مجلس الأمن أو الجمعية العامة للهيئة الأمم المتحدة، ولكن هناك دائما عملية ضغط وعملية مواجهة للاحتلال الإسرائيلي أمام القضاء الدولي. وأنا أؤيد أيضا ما ذهب إليه الزميل جان في قضية أيضا مسألة القضاء الوطني، هذه القضية مهمة جدا، ونحن نساهم في هذا المجال سواء في البحث عن المواد التي ممكن من خلالها الذهاب إلى المحاكم الوطنية وتجريم المجرمين الصهاينة في هذا المجال. لذلك يعني نحن كمجموعة قانونية، كمجموعة محامين، ونعمل لدى المحكمة الجنائية الدولية أو نساهم في الذهاب إلى المحكمة الجنائية الدولية مع زملاء آخرين طبعا وفرق قانونية أخرى. هذه القضية يجب أن تكون الشغل الشاغل لدينا. وقد تكلمت مع العديد من الزملاء أيضا في مسألة أنه لابد من إنشاء من تحضير ملفات قانونية قوية يتم عرضها إما على القضاء الوطني أو على القضاء الدولي. الأسرى يتعرضون إلى الكثير من الانتهاكات بحقوقهم سواء وهم داخل الأسر أو بعد خروجهم من الأسر. الآن مجموعة من الأسرى الفلسطينيين لا يستطيعون التنقل، ولا يستطيعون حتى العودة إلى فلسطين، ولا يستطيعون العودة إلى بعض الديار، يعني بعض البلاد المجاورة إلى فلسطين، وهم معتقلون داخل مجموعة من الفنادق في دول الجوار مع فلسطين. ولذلك يعني هؤلاء لهم علينا حق في أن نتابع قضاياهم، أن نحاول أن نضغط على الدول بأن تستقبلهم، وأن أيضا تدافع عن حقوقهم. هؤلاء الأسرى الذين تعرضوا للتعذيب يمكن أن يكونوا أيضا يعني مواضيع لتقديم دعاوى وإجراءات أمام المحاكم الوطنية وخاصة الأوروبية، لأنه كما ذكر الزميل جان بأن هناك مجموعة كبيرة جدا من الجنود الإسرائيليين وأيضا من يعمل في السجون الإسرائيلية لديهم جنسيات مزدوجة، ولذلك من السهل متابعتهم ومن ثم إلقاء القبض عليهم من أجل محاكمتهم لانتهاكهم القواعد القانونية. نحن نعلم بأن الوقت متأخر، ولكن الكثير من النقاط التي يمكن إثارتها في هذا الموضوع، والحقيقة بأنه الكثير من الملفات التي تم عرضها أمام المحكمة الجنائية الدولية، وآخرها كان في شهر 7 سنة 2025 هذه السنة، وقد قدمنا ملف بحدود تقريبا حوالي 400 صفحة حوالي في قضايا الانتهاكات التي تقوم بها دولة الاحتلال الإسرائيلي في حق الأسرى، سواء داخل السجون أو في داخل أو خارج السجون. والحقيقة يعني هناك كثير من الانتهاكات، منها أيضا قضية تغييب الأسرى الفلسطينيين واعتقالهم، لأنه لدينا الكثير الآن من الأسرى الفلسطينيين غير مسجلين لدى السجون الإسرائيلية. فهناك إذن ليس فقط الاعتقال التعسفي، وإنما أيضا هناك أيضا الإخفاء القسري ضد الأسرى الفلسطينيين. هذه النقطة لابد من إثارتها، بالإضافة إلى أنه الكثير من الأسرى الذين يعني يقتلون داخل السجون الإسرائيلية، ويمكن أن يؤدي ذلك إلى أيضا تعرض أجسادهم إلى الانتهاكات القانونية، انتهاكات حقوق الجثث الفلسطينية، وهو رأيناه في عادة الجثث إلى قطاع غزة. فهناك العديد من الانتهاكات، وقد وثقنا هذه الانتهاكات وعرضناها على محكمة الجنايات الدولية لدى المدعي العام لمحكمة الجنايات الدولية في آخر زيارة قمنا فيها في شهر 10 هذه السنة. أيضا قدمنا مجموعة من الملفات في هذه القضية، قضية انتهاك الجثث الفلسطينية التي أعيدت إلى قطاع غزة خاصة. وهذه المسألة من المسائل المهمة جدا. نقول بأنه أيضا التعاون المستمر ما بين الفرق القانونية، ما بين المحامين، وما بين أيضا مؤسسات المجتمع المدني. وقد رأينا أنه هناك مجموعة من المؤسسات سواء في فلسطين في قطاع غزة، أيضا في فلسطين الضفة الغربية وفي فلسطين قطاع غزة هناك مجموعة من المؤسسات التي تقوم بتوثيق ورصد هذه الانتهاكات والتواصل مع المحامين من أجل عرضها على القضاء الدولي أو القضاء الوطني الأوروبي. والحقيقة يعني مؤسسة هند رجب موجودة، مؤسسات نادي الأسير في فلسطين، في الضفة الغربية، في أيضا شؤون الأسرى، بالإضافة إلى مجموعة من المؤسسات الموجودة داخل غزة وقطاع غزة مثل حماية وغيرها أيضا، والتي تقوم بعمل حقيقة جيد وممتاز في التوثيق والرصد، ومن ثم إرسال كل هذه الملفات إلى المحامين من أجل فتح إجراءات سواء أمام محكمة الجنايات الدولية أو محكمة العدل، محكمة المحاكم الوطنية. وأعتقد بأنه أيضا لابد أن نلجأ إلى لجنة حقوق الإنسان ولجنة مناهضة التعذيب والفريق العامل والمعني بالاعتقال التعسفي أيضا والمقررين الخاصين، وهذه من المسائل المهمة. وحقيقة شخصيا أنا مع مجموعة من الزملاء أو الزميلات في بلجيكا ذهبنا إلى مجموعة من هذه الأدوات الموجودة والتي يمكن اللجوء إليها في القضاء الدولي، واستطعنا أن نحقق بعض النتائج في هذا المضمار. القضاء الفلسطيني طبعا ممكن أن يساعد أيضا في هذا المضمار وهذا المجال، والذي ممكن أن يؤدي دور في توجيه المحامين الدوليين من أجل متابعة المجرمين الصهاينة الإسرائيليين الذين يقومون بزيارات للدول الأوروبية. وهناك محاولات أيضا في الدول العربية من أجل ملاحقة من يقوم بالانتهاكات المستمرة في الضفة الغربية وقطاع غزة، وهذا يعني عمل يبقى على عاتق القانونيين والعاملين في القانون، وأيضا مؤسسات المجتمع المدني وخاصة المؤسسات التي تعنى بقضية حقوق الإنسان. ونحن أيدينا ممدودة للجميع. أعتقد بأن هناك زملاء موجودين لدينا ونستطيع أن نعمل سوية في هذا المضمار، في هذا المجال. عملت وأتشرف بالعمل معهم، جان والخاندرو الآن على ما أظن جديد بالنسبة إلي، لكن سوف نعمل سوية في هذا العمل في إسبانيا وغيرها. وأيضا الأستاذ حسن عملنا معا في هذه القضايا. وأعتقد بأنه هناك مجال لكي نتبادل الآراء ونتبادل أيضا الوثائق والملفات حتى نقوم بحماية حقيقية للأسرى الذين يقع حقهم علينا. نحن يعني أعناقنا مدينة لهم بهذا الصمود البطولي في داخل السجون الإسرائيلية، وأيضا هذه الإرادة لمتابعة المجرمين الذين انتهكوا حقوقهم في السجون لدى القضاء الدولي والقضاء الوطني. كل الشكر والتقدير، لن أطيل لأنه الوقت داهمنا، وأنا ممتن لكم والشكر للتحالف على هذه الفرصة القيمة لتبادل الآراء.
Thank you so much, Khalid, for that very important update and background to what you are working on. And we are running out of time. We have one last speaker, so we'll go directly to Alejandro Amaro, who is a Spanish human rights activist.
Buenas noches. Como nos queda muy poquito tiempo, yo tenía algo preparado, pero vamos a simplificarlo, ¿no? A lo sencillo. Solo será un manifiesto como activista que soy por los derechos humanos y por los derechos del pueblo palestino. En este manifiesto lo titulaba como los detenidos en los centros de tortura de la entidad sionista. Más de 11.000 hombres, mujeres y niños son torturados, librados de sus derechos y asesinados por los criminales sionistas. No respetan ni sus cuerpos, también roban sus órganos. La inmoralidad de esta entidad colonial no tiene límites. Mientras el mundo mira hacia otro lado, y lo más doloroso es la complicidad de sus hermanos árabes y musulmanes. Solamente quedamos nosotros, el pueblo libre del mundo, para defender sus derechos y presionar a los gobiernos del resto de países y desenmascarar sus verdaderas intenciones. Yo, como tantos activistas por la causa palestina, ponemos negro sobre blanco la cruda realidad de los detenidos y utilizamos todas las herramientas de las que disponemos. Las plataformas cada día censuran casi todo lo que compartimos y denunciamos en las redes, pero no nos dejamos intimidar. Cada meeting, cada reunión, cada manifestación, cada concentración en cualquier lugar de la geografía gallega, española, europea, africana o americana es un lugar para denunciar estas atrocidades. No debemos descansar en nuestra lucha. Cada pequeña victoria es un paso más para llegar a la solución del reconocimiento y la autodeterminación del pueblo palestino. Todos los detenidos tienen que regresar con su familia, todos en casa. ¡Viva Palestina!
Thank you, Alejandro. Thank you. And we do have some time left over for some questions. We have some questions that have been sent in through the chat, which I think I'll simply read some of them right now. One is, can we talk about how we can legally prosecute the entity that is responsible for the Israeli prisons? Another very important topic is the death penalty that was endorsed by the Israeli Knesset against Palestinian hostages and the stealing of organs. I don't know, Jan, I don't know if you want to try to tackle that, especially in terms of the recent law passed by the Knesset dealing with the killing of Israeli hostages and perhaps also the stealing of organs?
Yes, of course. Well, first of all, applying that penalty is, of course, an absolute violation of all rules of international law regarding to Palestinian prisoners. As we said, part of the Palestinian prisoners are actually protected by the Third Geneva Convention as participants, combatants in the conflict. And of course, executing prisoners of war is absolutely a war crime. Secondly, the civilians, as far as civilians who did not participate in the hostilities, it's obvious that it's a war crime. And that it's a blunt violation of the Fourth Geneva Convention. And as far as the administrative prisoners are concerned, well, the question there is, of course, how what category could they be placed in? I think the administrative prisoners are probably to be considered as hostages, and hostage taking as such is also a war crime, and especially executing hostages is indeed obviously a war crime. So I think there's no discussion possible that this law is totally illegal under international law, that we should fight it, that we should denounce these violations of international law with even more strength or force than what we have done until now, because it's about lives that are at risk, which makes it even more urgent to do so. So I think there is little discussion from a legal point of view that this is totally inadmissible, that this is a blunt violation of all the rules of international law. You can't put on trial prisoners of war, you can't put on trial civilians unless if they committed a crime, but I mean, not just because of their I would say their acts of resistance against the occupation. And so, as far as I'm concerned, the matter is really very clear. But of course, it will depend on our capacity to mobilize and to put to put pressure on our government and on international institutions to put pressure on Israel, and not just a diplomatic statement, but real pressure through sanctions, through blockade, through the end of weapons weapons deliveries, to the economic boycott, etc. And I think finally also, I think that should be an important point for all the solidarity movement, for Israel to be expelled from the United Nations, because they actually violate in all possible and in imaginable ways the Charter of the United Nations. You remember that the Israeli ambassador to the United Nations actually shredded the Charter publicly, which means you belong to an organization and then you say, we will in no way respect the fundamental laws of this organization. So there are very good reasons to expel Israel from the United Nations, which I think is that would be also one way to force our governments to express, to put pressure on Israel and to express their disagreement with, I would say, criminal laws like the one we have seen there.
Very good. Okay, it is 9 o'clock. I don't see any other direct questions. There's some very good recommendations that somebody came up with in the chat, but I want to thank all of our.
I want
Yes. Please.
أحب أن أضيف شيئا حقيقة فيما يتعلق في القانون الإسرائيلي الذي في قراءتين تم تبنيه من قبل الحكومة الإسرائيلية أو من قبل البرلمان الإسرائيلي، الكنيست الإسرائيلي، في قضية إعدام الأسرى. والحقيقة أنه الكثير من الأمور التي يمكن لدينا أن نعمل عليها في الضغط، سواء على الجمعية العامة للهيئة الأمم المتحدة من خلال القرار 377 متحدون من أجل السلام، أو لأن مجلس الأمن في هناك فيتو دائم مع إسرائيل، ولذلك يعني من الصعب تطبيق شيء لدى مجلس الأمن. لكن الجمعية العامة بقرار 377 اللي هو متحدون من أجل السلام، بالإضافة إلى هناك أيضا الذهاب إلى الجمعية العامة لتبني قرار الذهاب إلى محكمة العدل الدولية في قضية هذا القانون، لأن هذا القانون ينتهك كافة الأعراف والقوانين الدولية. لدينا هناك كما تكلمنا وتكلم الأستاذ جان في قضية اتفاقية جنيف الرابعة والثالثة، هناك احتلال لدولة فلسطين، هناك احتلال للأراضي الفلسطينية، الضفة الغربية بما فيها القدس الشرقية وأيضا قطاع غزة، هناك اتفاق دولي، هناك قرارات دولية. لذلك يعني نحن وهناك حق معترف به للفلسطينيين بأن يقاوموا هذا الاحتلال بكافة الأشكال وبكافة الوسائل، بالإضافة إلى أن هناك قرار دولي ومحكمة دولية بأنه إسرائيل لا تستطيع أن تتحجج في مسألة الدفاع عن النفس من أجل الذهاب إلى ارتكاب أيضا جرائم، سواء الإبادة الجماعية، جرائم الحرب وجرائم ضد الإنسانية، بالإضافة إلى أنها ترتكب أيضا جريمة العدوان. لذلك أنا أرى بأنه لابد لهذه الجلسة أن تتخذ قرار بحيث يتم مخاطبة السلطة الفلسطينية أو دولة فلسطين من أجل الذهاب إلى الجمعية العامة من أجل الحصول على قرار للذهاب إلى محكمة العدل الدولية في قضية الأسرى الفلسطينيين. وهذه يعني نقطة مهمة جدا يستحقها هؤلاء الأسرى القابعون في السجون الإسرائيلية. وكل الشكر.
Very good, thank you. Yafa, you've raised your hand if you'd like to pose a question.
Yes, thank you so much. Thank you to Mr. Jan, and thank you, Ustad Khalid, for bringing up the Uniting for Peace resolution. I understand that we need to push from the streets, and mobilizers should adopt the prisoners topic. However, what can we tell people who disbelieve in the UN system, especially after the Security Council has issued or endorsed or facilitated the resolution of Trump's plan, which was created to cover for the Colombia's proposal and the Uniting for Peace proposal? So how can we convinced people to believe in the system after the Trump's resolution failed Palestinian again, although we do believe that Colombia had the self-determination concept for Palestinian, and they have good intention towards solving this the conflict in general, or the situation, or enforce the ICJ rulings as well. So yeah, thank you.
Excellent question. Yes. I don't know who wants to take that one. Khalid, Jan.
انا اعتقد بانه الذهاب الى يعني مقترح كولومبيا في قضيه اللي هو انشاء جيش شعبي او جيش دولي من اجل الذهاب لحمايه الفلسطينيين، هذه من الفكر او الافكار المعقوله والتي يمكن ان يتم تبنيها، لكن وجود قرار من مجلس الامن في قضيه اللي هو القرار 2803 قاضي بانه نزع سلاح المقاومة، وأيضا الذهاب إلى مجلس السلام، هذه كلها أيضا تذهب ضد قرارات الشرعية الدولية. يعني مجلس الأمن يعارض نفسه بنفسه. الآن مجلس الأمن عارض قراراته السابقة، ويعارض أيضا قضايا مهمة جدا في القانون الدولي الإنساني. هناك لدينا قواعد آمرة جيسكو جونز، هذه القواعد الآمرة مهمة جدا. مسألة اللي هو قضية حق الشعوب في تقرير مصيرها، هذه من القواعد المهمة جدا. هذا القرار يذهب ضد هذه القاعدة المهمة جدا الموجودة في القانون الدولي. لذلك يعني أنا أرى بأنه والدولة الفلسطينية كان يجب عليها أن لا توافق على هذا القرار بالمرة، لأنه هذا القرار يعني خطير جدا ويحمل في طياته انتهاكات قوية جدا للقانون الدولي الإنساني والقانون الدولي بشكل عام. ولذلك يعني لابد من الضغط كما ذكرت على دولة فلسطين أيضا، ويعني وجه خطاب لدولة فلسطين لانسحاب من هذا القرار، وأيضا ممارسة الضغط على المجموعة الدولية من أجل تبني ما ذهبت إليه الأستاذة يافا في قضية اللي هو الذهاب إلى متحدون من أجل السلام، من أجل أيضا تبني وجهة النظر الكولومبية، ومن ثم الذهاب إلى إلغاء هذا القانون. طبعا لابد من العمل مع فرق قانونية من أجل إبطال هذا القرار 2803. هذا قرار يجب إبطاله، ويجب أن نسعى جميعا لكي نضعه في خانة اللي هو السبات والإبطال. وكل الشكر.
أحمد.
مرحبا، مساء الخير. سؤالين. مسألة التعريف الإسرائيلي لمقاتل غير شرعي، ونعلم يعني أنه فيها تعدي ولكن كيف يمكن إبطال أو إفراغ هذا المصطلح مقاتل غير شرعي تستخدمه إسرائيل؟ There is no translation.
No.
Okay. So, maybe I didn't open the option. Anyway, my first question is about the illegal fighter, the term used by Israelis for the kidnapped Palestinians and the hostages in illegal prisons or in the military bases. So, illegal fighter. How we can deal with that term and how we can fight against it. And the second question, how to use the stories like using the dogs for in the violations of the prisoners, like to make it like a media bomb, to abuse it or to use it in the solidarity movements, because it's one of crimes, and it became like a normal crime, or it was lost in these crimes. So even if it's a huge, crime, but it was lost. I think that it didn't get the best value and meaning of this crime. So abusing the dogs in the violations and the animals. For example, I had an idea to invite all the organizations of defense of animals in Europe even to make like steps, legal steps against abusing the animals in the complicity of these crimes against Palestinians. So it's one of ideas. So how we can use that legally to use it in our movements, solidarity movements, for example, in Europe or otherwise. Thanks.
Very good. Jan, would you like to comment on that? And I'm sure you had other things to say as well.
I would like to say first something in relation to the previous question. I think our problem is not to convince people to have confidence in the international institution or in the international system in the UN. I think what we need to explain is that we are in a situation in relation to Palestine, but also broader because it spills over to other situations where it's either the rule of law or the rule of the jungle. We go one way or the other way. International law, a lot of international law, at least the part of international law we stand for, the Charter of the United Nations, which forbids aggression and the use of force in international relations, the right to self-determination enshrined in the UN covenants, are all results of people's struggle. The Universal Declaration of Human Rights and the Charter are actually the result of the resistance against the Nazi aggression wars and against the incredible violations of the most basic human rights by the fascist countries during the Second World War. The covenants that enshrine in international law the right to self-determination are a direct consequence of the anti-colonial struggles. It's a reflection of the anti-colonial struggles. So we should not throw that away. These are, I would say, this is our acquis. This is what people throughout the world fought for and were able to enshrine finally in international law. The international system, and then I'm speaking especially about the UN, is actually, as far as I'm concerned, the battlefield. So I have no trust in the battlefield. I have trust in our capacity to go to the battlefield and to win the battle, which means that in the UN, we have to fight that fight to protect international law and to protect people's rights and to protect the rights of the Palestinian people, like we do it everywhere else in the world. And I think that is often people think that the UN will solve the problems. Of course not. The UN reflects the reality of the world with all its contradictions. And so it's a battlefield where we have to try to fight for the rule of law against those within the international institutions that want to impose the rule of the rule of the jungle. And the last resolution that was voted by the Security Council is obviously an expression of the rule of the jungle. It's the expression of it's the denial of all basic principles of the Charter of the United Nations, of the right to self-determination, and of all these international instruments. It's a complete denial of that. So, of course, we should fight it. But on the other hand, we know that the countries of the Hague Group are uniting, and it's very important that countries are uniting to oppose the Israeli aggression and to support the Palestinians. So that is the battlefield between different groups of countries and different groups of people that are present in the United Nations. And then the second question, yes, of course, we should very clearly denounce all these violations, including the most disgusting ones that we have seen. We should make them public. We should make the public aware of this, and we should do whatever we can. And probably there are different ways. In relation to the question of this illegal combatants, well, that is precisely related to the questions we discussed in the beginning. The right to resistance, and the question whether, as long as combatants comply with the conditions of Article 4.2 of the Third Geneva Convention, whether they are recognized as forces of resistance, yes or no. And I think it's obvious for the Palestinian combatants and fighters that that is absolutely so, and that therefore the talks of Israel about illegal combatants is actually completely in denial of the Third Geneva Conventions, which is ratified by Israel, but of course not applied like all the rest of international law.
Okay, thank you. We have one final question from Hamdan.
Oui, merci. Moi, je peux parler en français ou en arabe? In Arabic or in French?
Your
I have
choice.
difficult to English from English.
حسب شو حاطط انت عندك في
لا أنا مش حاطط
يطلع
شيء.
تطلع الترجمة زي ما
لا ما حطيت شيء، بس بالفرنسي فينا أحكي ده
اوكي واضح
بسرعة.
قاعد بالترجم
Ok. Ok, merci. Moi, je voulais revenir sur la détention administrative. Depuis que je m'intéresse personnellement à la question des prisonniers palestiniens, tout le temps, on a des milliers de Palestiniens qui sont arrêtés et jugés sur la base de la loi de la détention administrative. On sait très bien que la détention administrative est une loi qui remonte à la présence anglaise en Palestine, et je dirais les Israéliens la pratiquent depuis le début de l'occupation jusqu'à maintenant. Actuellement, d'après les sources des institutions palestiniennes qui s'intéressent aux prisonniers palestiniens, plus que la moitié actuellement déjà condamnés, jugés dans les prisons israéliennes, plus que la moitié, ils sont jugés sur la base de la loi administrative. Donc ma proposition, pourquoi, en profitant maintenant de l'élan de solidarité dans le monde avec la Palestine, avec le peuple palestinien, pourquoi on ne pose pas cette question à l'échelle internationale, soit par des pays dans le cadre de l'Assemblée générale des Nations unies ou au niveau, je dirais, de la société civile dans le monde, les institutions, les mouvements de solidarité, pour obliger Israël à arrêter les pratiques et l'utilisation de la loi administrative contre les Palestiniens. Moi, je pense que ça se mérite qu'il y ait une campagne internationale justement pour condamner Israël à arrêter de pratiquer la loi administrative parce qu'elle est complètement illégale. Voilà ma proposition. Shukran.
Before anybody takes that, Bernard has offered to summarize that question for us in English. Unfortunately, the translation did not work. Bernard, will you be able to? Great, thank you.
Yes, he proposes that the question of the new laws that are completely illegal, they should be brought onto the international scene and debated in the international into an international space on the basis of their legality in international laws. They just have to be brought out of that space where they're not talked about into an official space of discussion in international law.
Great, thank you very much. So,
Du hast dein Mikrofon ausgemacht.
Yeah, thank you. Thank you, Bernard. And we have Abdelhamid Siam has returned, so perhaps Abdelhamid, if you would like to address that question. Or anyone, of course, Jan or
administrative detention is generally legal in every country in the world, that when you arrest somebody, you keep him for some time until you put him on trial. Israeli practices defies that. There is administrative detention that is endless. They keep extending the detention, sometimes 2 years, sometimes 3 years. That's one thing. Second, they don't tell you what you are accused of. They just arrest you, put you in the administrative detention without explaining why, which is, again, it's illegal. So the way it is arrested is illegal, and the way they keep you there, it's illegal. Third, they deny anyone who is in the administrative detention any contact with any lawyer. They don't, because according to their logic, it's, oh, you are temporarily there. You don't need. You can contact a lawyer once you go to the court. Once you are not going to the court, that you don't need to see a lawyer. And during that administrative detention, all violation against the sanctity of the person could be applied, because there is no trial, there is no sentence. This person is not in yet serving a term and a sentence, so they can abuse that person at their own will. And many of them they collapse during this administrative detention. The other thing is also that applies to children, which is, it's illegal again. So they are committing so many crimes with this administrative detention. For example, one of the children, which was taken and placed in administrative attention, he lost his mind because he was abused by someone during that period, which is believed to be implanted by the Israelis in during the administrative detention. And that person who was supposed to leave, they kept denying him that. And then, as we all know, I don't want to mention his name, he lost his mind. So this is one of the major crimes that the UN reports, which is, there is a monthly report, come to the Security Council, including one happened Monday. They don't talk about prisoners of war. They don't talk about administrative detention. They don't talk about children. They only give a report about the violation in West Bank, about the settlers, about what happened in Gaza. Almost every day there is a report. What is missing is always, I don't know why I kept raising that issue. Remember my brother Khalid in our conference in Malmo, when I spoke about that. And I urged everyone to pressure both the Palestinian Authority and the UN officials who bring those reports. They don't talk about prisoners. They don't talk about their torture. They don't talk. Maybe they could mention an example of someone like Dr. Hussam Abu Safiya. Maybe, yeah, that's because that could be used as an argument in the Security Council, and some Pakistani ambassador, Algerian ambassador, Palestinian ambassador mentioned Hussam Abu Safiya. But the detention and the children and the trial and the military trial of children and the torture of women and all that, and now the sexual abuse of women and men, and the new the volume of information coming from the detention center of Sdei Timan, or Taiman, I don't know how we pronounce it. Hassan Abbadi should correct me. Sdei Timan. And there is a book issued by our friend Ali Abu Hilal about this detention center, which is, it's really, it should be read by everyone. So that is what I want to say about that. And it's one of those crimes that committed by Israel. And what we should really keep fighting to make sure that international humanitarian law applies to everyone. And we have to keep banging on the wall until that becomes a global culture, not only about the violence of the settlers or the destruction in Gaza, but also the treatment of Palestinian, thousands of Palestinian prisoners. Thank you.
Thank you very much. And I want to thank all. of course.
هل استطيع ان اتكلم بس كلمه في قضيه اللي هو الاعتقال الاداري. الاعتقال الاداري هو منظم ايضا في اتفاقيه جنيف الرابعه، الماده 78 من اتفاقيه جنيف الرابعه تقول تجيز القوه المحتله لاسباب امنيه قاهره ان تتخذ اجراءات الرقابه الامنيه ضد الاشخاص المحميين بما في ذلك تعيين محل اقامه او اعتقال الشخص. لكن هذه الماده تجيز لكي يكون هذا الاحتجاز لأفراد معينين، لأشخاص معينين، قضايا فردية صغيرة جدا. وتحت شروط وأيضا حالات معينة. المسألة ليست مفتوحة على الغارب. يعني المسألة الثانية الإجراءات التي تقوم بها دولة الاحتلال الإسرائيلي، الممارسات ضد الفلسطينيين في قضية الاعتقال الإداري، لأنه أصبحت قضية ممنهجة، ولذلك يعني خرجت من نطاق المشروعية في الحالات القهرية إلى أن تصبح جريمة حرب أو جريمة ضد الإنسانية. هذه تحتاج منا دكتور أستاذي يعني تحتاج منا إلى تضافر الجهود جامعا لكي نذهب إلى الجمعية العامة. وأعتقد بأنه وضعك أنت أيضا وخبرتك وأيضا علاقاتك تستطيع من خلالها أن نكثف هذه الجهود لكي نطلب من الجمعية العامة أن تذهب إلى محكمة العدل الدولية لإصدار أيضا رأي استشاري في هذه المسألة، لكي تصبح القوة قانونية ضد دولة الاحتلال الإسرائيلي. لأنه هذه المسألة يعني كل مسائل الأسرى الفلسطينيين والمعتقلين الفلسطينيين سواء تحت اتفاقية جنيف الثالثة أو الجنيف الرابعة تحتاج إلى هذا العمل وهذا الجهد الجمعوي حتى نستطيع فعلا أن نقدم شيء للأسرى.
I just want to say something that the General Assembly will not go by itself. You need a group of countries. You need countries to table a draft resolution. This draft resolution should be voted on the way they did, for example, with the issue of occupation. They asked the General Assembly to request the ICJ to give a legal opinion about the Israeli perpetual occupation. The ICJ took the resolution from the GA, debated it for 1 year or more even, and then they issued the legal opinion on July 19, 2024. The same thing with the wall. The GA asked, after a resolution tabled by the Palestinians and their allies, of course, the ICJ gave the an opinion on July 9, 2004, and so on and so forth. So what you say, I agree with you 100%. But you need that dynamo. You need that group of countries who push the issue before the General Assembly. Thank you.
Thank you. And to get the group of countries, we have to be working in the streets to force our governments to use these institutions. So that is something I think we all need to remember as we continue with this fight, with this battle, and how important this is, as we've just heard this evening. I want to thank everybody for being here this evening, especially our distinguished panelists. I would also like to remind everybody that Asra, the European Alliance in Defense of Palestinian Detainees, is a working organization. We have a website still under construction. Please visit it, Asra, www.asra-palestina.org. Thank you again, everybody, for being here, and please keep in touch. Hope to see you all soon.